Tantor Audio, a division of Recorded Books, presents Wrongful Convictions and Forensic Science Errors, Case Studies and Root Causes, by John Morgan. Narrated by Perry Daniels. Chapter 1. Context of Wrongful Convictions and Forensic Science Errors. Introduction. Since the beginning of human civilization, governments have adopted and enforced criminal codes. Governments derive legitimacy from the fair and effective management of their criminal justice systems. They may vary with respect to goals. Some governments emphasize order and punishment and seek to establish a rule of law that prevents chaos. Other governments emphasize freedom, equity, responsiveness, or other values related to their structure and place in history. Criminal justice systems usually act with impunity, which is the ability to act without fear of punishment or repercussions. There are limits to that impunity, which may lead citizens to seek redress or revolution. Although some totalitarian governments abuse impunity to impose terror on their citizens, such Orwellian dystopias have not proven to be long-lived. As a result, most criminal justice systems are designed to identify and punish those who offend against the law and err toward leniency when in doubt. The idea is echoed in many religious texts, and it is notable that a major world religion, Christianity, is based on a story of wrongful conviction. Scholars illustrate the breadth of the idea that wrongful convictions come at a high societal cost. Jewish scholar Moses Maimonides said, "It is better and more satisfactory to acquit 1,000 guilty persons than to put a single innocent man to death." Later, Benjamin Franklin advocated for a ratio of 100 to 1, while English jurist William Blackstone said, "It is better that 10 guilty persons escape than that one innocent suffer." It might disturb the listener to observe that the acceptable ratio appears to have been in decline over the centuries. Nonetheless, Blackstone and others have recognized the problem of wrongful convictions and attempted to establish legal frameworks that were intended to produce reliable verdicts. By the early 1900s, many legal scholars in Western societies were convinced that the legal system produced very few, if any, wrongful convictions. Although corruption and incompetence were recognized, it was believed that common law traditions and modern processes like appeals courts could prevent systematic injustice. During this period, there were high-profile exonerations, including several cases that resulted in presidential pardons. Most cases involved mistaken identity, in which a crime victim testified in error concerning the actual perpetrator. Others, such as the Oscar Kruger case, included errors related to forensic evidence. The cases were usually considered isolated errors until the work of Edwin Borchardt, a Yale law professor who wrote Convicting the Innocent, 65 Actual Errors of Criminal Justice. Borchardt highlighted the stories behind many wrongful convictions and was an early advocate for compensation for the wrongly convicted. The father-daughter team of Jerome and Barbara Frank contributed Not Guilty, 1957, following the style of Borchardt in providing narrative descriptions of individual cases. These efforts established that wrongful convictions were more prevalent than was widely believed within the criminal justice community. The specific role of forensic science was not highlighted in these early works. Oscar Kruger. Oscar Kruger was wrongfully convicted in 1910 of mailing obscene materials on the basis of an invalid handwriting examination. In 1910, in New York City, a young woman seeking employment received an anonymous, obscene letter. She took the letter to the Society for the Prevention of Vice, which had been founded by Anthony Comstock. Comstock was a well-known activist against pornography and sexual vice and for moralistic censorship. He agreed to help the woman. Comstock arranged to entrap the offending writer using a ruse that implicated Oscar Kruger, a married man with 2 children. Comstock believed that Kruger's handwriting matched that of the letter writer, an opinion confirmed by a handwriting expert. They focused on the name Washak, which was the last name of the victim and had been written on the envelope that contained the offending letter. Kruger was then charged and convicted of violating Section 211 of the U.S. Code, which outlaws the mailing of any obscene, lewd, lascivious, indecent, filthy, or vile article. He did not have the funds to hire an independent handwriting expert. After his conviction, Kruger wrote letters to the President and Attorney General protesting his innocence. An assistant U.S. attorney, Daniel Walton, reinvestigated the case and retained noted handwriting expert William Kinsley, who determined that Kruger was not the writer of the offending letter. Despite Comstock's opposition, Walton's recommendation for pardon was accepted, and President Taft issued him a pardon on January 18, 1912. As Borchardt put it, Comstock's sincere, though often misguided fanaticism induced in him gullibility and carelessness in fastening so serious an offense on an innocent man, and these characteristics were combined with exceptional stubbornness and unwillingness to admit error. Handwriting expert Kinsley wrote a book, Tales Told by Handwriting, that popularized handwriting examination. Nonetheless, the field would lack comparison and testimony standards for many decades afterward. Forensic science in the 20th century. Around the same time as the Kruger case, Edmond Locard established the first police crime laboratory in Lyon, France in 1910. Locard developed basic standards for fingerprint identification, including the standard of using 12 points to establish a definite latent print match. In the United States, Calvin Goddard established the FBI laboratory in 1924. Goddard's work in ballistics had been heavily influenced by the experience of wrongful convictions. On Sunday evening, March 21, 1915, between 10 and 11 o'clock, Charles B. Phelps, an aged farmer residing in the town of Shelby, Orleans County, and Miss Margaret Wilcott, his housekeeper, were both murdered by being shot with a revolver containing .22 caliber cartridges and bullets. The case involved Stilo's false confession, prosecutor misconduct, and inadequate defense. Stilo owned a .22 caliber revolver, which was matched to 4 autopsy bullets by self-taught firearms expert Albert Hamilton. Hamilton had awarded himself a phony medical degree and advertised as a criminologist with expertise in chemistry, cause of death, anatomy, and firearms identification. Hamilton did not show his findings to the jury at trial, contending that the work was so technical that only an expert could understand it. At the time, there were no standards for the forensic profession in general, or the practice of ballistic identification specifically. Stilo was sentenced to death, Green to 25 years to life in prison. While awaiting his execution at Sing Sing prison, Stilo related his case to prison officials, who conducted their own investigation. Stilo came within 40 minutes of execution when a stay was ordered. Afterwards, alternative suspect Irwin King was identified and eventually confessed to the crime, but Stilo's conviction was not overturned. Governor Whitman took an interest in the case and ordered an investigation by a former district attorney, George Bond. Bond hired Charles Waite from the New York Attorney General's office to re-examine the ballistic evidence. In turn, Waite enlisted Henry Jones, a firearms expert with the New York City Police Department. Waite and Jones conducted test fires, in which several rounds from the Stilo revolver were fired into cotton batting. Further assisted by optician Max Poser, they established that the bullets were dissimilar from the autopsy bullets in every regard. Stilo and Green were subsequently pardoned by the governor. King was never indicted for the murders. Waite would go on to work with Calvin Goddard, physicist John Fisher, and chemist Philip Gravel to establish a Bureau of Forensic Ballistics in New York City and develop the comparison microscope, which is still used today in ballistic identification. With the support of influential police executives, including FBI Director J. Edgar Hoover, Goddard and his colleagues established the training and practice standards that ushered in an era that was associated with scientific crime detection. They were heavily influenced by Sherlock Holmes and scientific positivism, which held that all true knowledge is scientific. They believed that forensic science could definitively establish the facts of a crime. Their view was neatly summarized by Locard's exchange principle: every contact by a criminal leaves a trace. The job of the forensic scientist was to find and characterize these traces and associate them with sources or activities at the crime scene. Criminologists adopted their own brand of positivism, holding that an individual's personality or background would make the person more prone to antisocial or criminal behavior. This view was reinforced by the growing evidence that crime was often committed by repeat offenders. Although scientific positivism led to many improvements in forensic science and law enforcement, it failed when pseudoscientific theories were given inordinate credibility. For example, the Bertillon system used morphological characteristics such as face shape as methods of identification. Bertillon identification was successful for a time, but eventually was supplanted by fingerprint identification. There remained a belief that criminals would have morphological characteristics that would make them look like a comic book villain, a pernicious view that may have contributed to wrongful convictions in many cases. Oscar Kruger had what was called a mesomorphic body type, being muscular and big-boned, which was theorized to be associated with a propensity to criminal delinquency. At the same time, police agencies adopted a professional policing model that emphasized a constrained role for law enforcement. Summed up by the "just the facts, ma'am" dragnet detective, the professional policing model emphasized rapid response and solving crime. Agencies avoided community interaction or prevention efforts, which were thought to lead to police corruption, and often did. Forensic science in the Locard-Goddard model was a natural adjunct to professional policing because it also emphasized fact-finding and solving crime. Police agencies started crime laboratories or standalone units to support investigation in the mid-20th century in the expectation that forensic science would support the law enforcement mission. In fact, crime laboratory directors and forensic discipline scientific working groups were originally organized by the FBI laboratory. The close relationship between forensic science and law enforcement continues to this day and has been the subject of criticism from wrongful conviction researchers who believe that it leads to biased decision-making. Many forensic scientists defend the practice. Historically, the relationship has led to more resources for the development of laboratories. Many police leaders have been strong supporters of research and scientific standards. Most notably, Berkeley, California Police Chief August Vollmer is widely considered the founder of professional policing and introduced many new ideas into policing, including radio systems, record systems, and lie detectors. He encouraged the development of crime laboratories and was largely responsible for the establishment of the Los Angeles Police Department Laboratory and the International Association for Identification. The International Association of Chiefs of Police still gives an annual August Vollmer Excellence in Forensic Science Award for innovative use of forensic science. As the Kruger and Stilo and Green cases demonstrate, the fields of ballistics and handwriting identification required significant development of their scientific foundations and practice standards. These gaps existed across the disciplines. For many disciplines, individual innovators would play key roles. For example, Albert Osborne is often considered the father of questioned document examination. Among other innovations, he recognized individual variations in the ability to discern visual patterns and developed the form blindness test to predict the ability of novices to become good handwriting examiners. As disciplines matured, professional associations and scientific working groups produced consensus standards to govern training, certification, methods, and testimony. These governance mechanisms establish the scope and best practices associated with a wide range of disciplines and worked well when connected to public laboratories that were well-led and well-funded. They also had significant limitations. The groups seldom had sufficient representation from scientific researchers, leading to standards based on the experience of practitioners, not empirical scientific research. Because practitioners had limited feedback concerning errors, they could have unrealistic expectations about the reliability of their methods. Also, professional associations possessed weak enforcement mechanisms, meaning incompetent or fraudulent examiners were able to continue to practice with insufficient accountability. Even when disciplinary actions were taken, an examiner could continue to work in many jurisdictions. Many examiners worked without sufficient training or meaningful certifications. This phenomenon was most clearly demonstrated in fingerprint units, which were, and remain, often located within police departments, not independent crime laboratories. The units were primarily staffed with examiners, who possessed the ability to do 10-print checks to identify a suspect, but often were insufficiently trained to do the much more difficult task of latent print identification. These individuals may have been police officers themselves, so they were susceptible to making biased, inculpatory, and possibly erroneous identifications. Local jurisdictions seldom possessed sufficient review mechanisms to identify these problems, and the national governance bodies were even weaker. In some disciplines, even certified examiners may not have had the ability to perform difficult comparisons. The professional associations relied on revenue from training and certification regimes and had the perception that difficult testing would disincentivize participation by practitioners. The associations were particularly reluctant to decertify practicing forensic scientists. Many wrongful convictions were related to these gaps in forensic science governance. Governance gaps remain to varying degrees to the present day. The scientific working groups are now managed by the National Institute of Standards and Technology, NIST, under the Organization of Scientific Area Committees, OSAC, the Organization of Scientific Area Committees for Forensic Science, and NIST. Some professional associations have stronger certification and standard structures, particularly in chemistry and toxicology. DNA evidence standards are enforced in connection with the National DNA Index, although the FBI continues to play the central management role. Most public laboratories are now accredited and enforce professional and practice standards through formalized quality assurance. Some jurisdictions have oversight boards, such as forensic science commissions, that have different enforcement powers. Outside the United States, national forensic regulators have been established and enforce standards with varying levels of success. Nonetheless, many disciplines continue to rely on weak governance. For example, bite mark examiners are governed by the American Board of Forensic Odontology, ABFO, which is connected to the American Academy of Forensic Science, AAFS. ABFO moved slowly to recognize the well-established limitations of bite mark comparison to identify an individual biter. It lacked the power to enforce the standards it put in place, even when it decertified an examiner. Forensic evidence standards in criminal cases. Legal scholars maintain that the courts are best positioned to enforce meaningful scientific standards. Before the Frye Rule was established in 1923, courts accepted an expert opinion if it was based on special experience or special knowledge. The Frye Court extended this concept when it was faced with the admission of lie detector testing based on the measurement of systolic blood pressure. Although the lie detector test was administered by an expert, the scientific foundation for polygraphy was lacking. The Frye Court held that scientific evidence could be admitted only when it was sufficiently established to have gained general acceptance in the particular field in which it belongs. On this basis, it rejected the systolic blood pressure deception test. In response to Frye, polygraphers established a professional organization, the American Polygraph Association, APA, which provides training and standards for the field and publishes a scientific journal, Polygraph. Although the work of the APA and similar organizations may be considered by some to meet the Frye general acceptance test, polygraphy is not accepted in court in many jurisdictions today. Almost a century after Frye, the scientific consensus holds that polygraph has some value to discriminate lying from truth-telling when used to investigate specific incidents, such as crimes, but the technique is subject to many confounding factors and can be abused as a screening tool. The Frye General Acceptance Rule has many weaknesses. First, judges are in a poor position to determine whether a particular method is generally accepted by the relevant scientific community. Also, advocates or self-described experts could misuse or exaggerate the value of a method. In 1976, the Supreme Court of California adopted the Kelly-Frye test to address these issues to a limited extent. The court was considering voice print identification, a technique used to associate a recording with an individual's voice. As practiced at the time, voice print relied on analog tracings of the intensity of a recording within frequency bands. The Kelly-Frye court rejected the testimony of a voice print examiner who was primarily a technician, not a scientist, and was an advocate, not an impartial judge of the scientific merit of the method. The Kelly-Frye test requires that scientific techniques must show general acceptance and be presented by a qualified expert using the correct scientific procedures. The test also prohibits the expert from speculating concerning an opinion outside the bounds of the subject. Many wrongful convictions include forensic testimony that would violate the Kelly-Frye standard if applied properly by a judge at trial. The courts may fail to recognize the novelty of methods or allow experts to speculate on matters that are outside their expertise or the bounds of validated science. David Sean Pope, Pope v. State, 1988. On July 25, 1985, a young woman was raped in her apartment in Dallas, Texas. The rapist called her later that day and again on July 27th, at which time her answering machine recorded the call. A 10-minute phone conversation with the rapist on August 2nd was fully recorded. David Sean Pope was a former resident of the same apartment complex. He had been found by the management of the complex loitering in the neighborhood on multiple occasions after his eviction in June. On August 28th at 6:30 a.m., Pope was arrested by police while wandering the premises of the complex. He was found with a 9.5-inch knife, similar to the weapon used by the attacker. His white pants and general description also matched the victim's description. Investigators attempted to match Pope's voice to the recordings of the victim's answering machine. Houston police officer Larry Howell Williams, who had performed 1,000 voice print comparisons, and Dr. Henry Truby, an expert with a Ph.D. in acoustic phonetics, testified that a reference voice recording and the voice from the answering machine were from the same source, David Sean Pope. Truby further testified that voice spectrography could identify an individual to the exclusion of all others in the world, just like fingerprints. Pope's defense lawyer called Stuart Ritterman, a professor from the University of Florida, who questioned the scientific validity of the technique. The trial judge accepted the identification testimony under the Frye standard, then in use in Texas. Pope was convicted. The Texas Appeals Court noted that Truby's testimony was contradicted by the most important research then extant on voice print spectrographic analysis, that of Oscar Toji at Michigan State University. Toji found false identification error rates of 2.4% under ideal conditions. The court also cited a 1976 National Academy of Sciences study of voice print identification, which raised serious concerns about confounding factors, including deliberate attempts to disguise a voice, recording fidelity, and the subjectivity of examiner decisions. The appeals court wrestled with how to apply the Frye standard in the case and cited 25 different cases in which state and federal courts had come to wildly divergent conclusions about the admissibility of voice print analysis. Although the court held that voice print evidence was improperly admitted, the majority held that the error was harmless. 11 years later, the Dallas district attorney followed up on a tip about the case with a DNA test on the rape kit from the crime. Pope was exonerated, received a pardon from the governor, and received $385,000 in compensation, plus a $6,500 a month lifetime annuity. The case demonstrates the limitations of the Frye standard, but more fundamentally shows that the courts are poorly equipped to review scientific evidence. Voice-print spectrographic analysis is not a singular method that is applied in the same way by all practitioners. The technology has changed over the years. Practitioners use digital analysis to examine different patterns and frequency bands. The research has revealed many confounding factors and suggested many strategies to account for those limitations. Even if Truby had correctly described the research and cited Toshi's work, he was not applying the same technique that Toshi used. No voice-print identification technique has been validated to the point of establishing a reliable error rate in practice. In 1975, the federal government adopted the Federal Rules of Evidence, FRE. FRE Section 702 is the primary rule that relates to forensic evidence. FRE 702 emphasizes the background of the expert, the relevance of the expert's testimony, and the reliability of the expert's methods in principle and as applied. The term in principle relates to the ideal application of the method. The term as applied relates to the way the method is actually applied by the expert. Specifically, FRE 702 states, "A witness who is qualified as an expert by knowledge, skill, experience, training, or education may testify in the form of an opinion or otherwise if a. The expert's scientific, technical, or other specialized knowledge will help the trier of fact to understand the evidence or to determine a fact in issue. B. The testimony is based on sufficient facts or data. C. The testimony is the product of reliable principles and methods. And D. The expert has reliably applied the principles and methods to the facts of the case." Although FRE 702 formally applies in federal court, its principles are incorporated into most state rules of evidence through the Daubert standard or other mechanism. The U.S. Supreme Court established the Daubert standard in a civil case in 1993, relating to whether the drug bendectin would cause birth defects. The Daubert court adopted FRE 702 by reference and added a series of tests for scientific validity. Number 1, has the theory or technique been tested? Number 2, has it been subjected to peer review and publication? Number 3, what is the known or potential error rate? Number 4, are standards maintained controlling its operation? Number 5, is it widely accepted with a relevant scientific community? In his decision, Justice Blackmun clarified that the standards were flexible and should be judged based on the principles and methodology of the theory or technique. The Daubert decision was heavily influenced by the ideas of philosopher of science Karl Popper. Popper emphasized that the validity of scientific hypotheses required that they be falsifiable. He pointed out that adherents tend to make observed reality fit their predictions. As a result, even if you verify a hypothesis many times, it has not truly been tested until you try to prove it was wrong. In forensic practice, this implies that a method should not be adopted solely on the basis of its success in casework. The underlying assumptions of the method should be tested as falsifiable hypotheses. For example, toxicologists assume that a level of alcohol observed in breath measurements directly correlates with levels of alcohol in the blood. The principle could be verified using roadside testing machines and blood sampling that shows the relationship. But Popper would hold that to be an insufficient empirical test. Instead, the researchers should conduct a controlled experiment to produce known levels of blood alcohol in test subjects, predict breath alcohol results, and determine whether the predictions were valid. Although Daubert and FRE 702 provide a more thorough approach to the review of forensic science by the courts, wrongful convictions demonstrate that significant gaps remain in the review of scientific testimony. Judges and lawyers continue to lack education and training in the increasingly sophisticated science and technology that is presented in trials. Dubious methods may be accepted. Faulty testimony may be presented without objection. In many circumstances, defendants may be faced with an adversarial deficit in which their counsel has fewer resources or capabilities than the prosecutor. Forensic science issues.
Sample complete. Ready to continue?